I want to thank everyone who's physically here joining us for this event, and for all other attendees who are currently joining us virtually for the workshop on understanding and implementing the Common African Position on Asset Recovery, or commonly known as the CAPAR. This workshop is organized by the Secretariat of the African Union High-Level Panel on Illicit Financial Flows from Africa, in collaboration with one of the forefront agencies of the government of Nigeria dealing with anti-corruption, the Albany State University, here based in Georgia, USA, and other members of what we call the CAPAR Working Group. I myself am Oladipo Johnson, working at the Coalition for Dialogue on Africa, or CoDA, which operates as a secretariat of the high-level panel, which I mentioned earlier. To some of you, you will probably know it as the Thabo Mbeki panel as well. As you know, it was one of those panels that released its report in 2015, after which its recommendations were passed by the African Union heads of states and government as a special declaration on illicit financial flows. This is what formed the foundation of what is now known as the CAPAR, because several recommendations of that report from the panel essentially pointed directly to issues of asset recovery and the much needed efforts by African and non-African stakeholders to gather around this issue and support its holistic recovery. It also confirms Africa's rights for the return of all its illicitly removed or stolen assets, including cultural artifacts as well. And that is why the CAPAR is so crucial to us, and the CAPAR Working Group, many of its members which form the panel which you're looking at today, was constituted. The working group was firstly put together to develop what is the Common African Position now, and I must add that it was unanimously and immediately passed by African Union heads of states again in February 2020. Now the group works to ensure that all stakeholders on the continent and outside of it are fully sensitized on what the CAPAR means, and also works to guide its full implementation. Accordingly, you will hear much of the details of the CAPAR today, which ultimately is a plan to achieve the recovery of assets for Africa without infringing on the sovereign rights of its citizens. So without further ado, I want to introduce the speakers for the opening session of this workshop. To the second on my left, we have Professor Bolaji Owasanoye. He is the chairman of the Independent Corrupt Practices and Other Related Offences Commission, the first and pioneer anti-corruption and integrity institution in Nigeria. He's also served as the executive secretary of the Presidential Advisory Committee Against Corruption in Nigeria. And recently, he was awarded one of the highest national honors of the country as an officer of the Federal Republic. Thank you. To my immediate left, I have Barrister Akere Muna, who will be chairing and moderating our entire workshop today. Many of you know him as a member of the aforementioned high-level panel on illicit financial flows. Many of you...
Secretariat of the African Union High-Level Panel on Illicit Financial Flows from Africa. That secretariat is the Coalition for Dialogue on Africa, CoDA. Also in this partnership is the Pan-African Lawyers Union, the Albany State University, Graduate School of the USA, and of course the CAPAR Working Group. The trajectory of advanced economies tell us that they develop largely on domestic public resources. Therefore, leaving the matter of illicit financial flows from Africa unattended is an existential issue, because on the one hand, Africa is carrying a debt burden and in search of cheap loans and overseas development assistance, yet there is this huge leak of illicit financial flows going on since pre-colonial days that we are yet to plug. And there is an active pushback from the global north where a lot of these assets end up. And this pushback also affects the efforts to recover stolen and diverted assets. COVID-19 pandemic is the most recent illustration that domestic public resources are critical to meeting your own needs through the central role of the state. So, ending IFF requires action at different levels, at the national level, the continental or regional level, and global international cooperation. We recognize that there are vested interests at each of these levels of action that prefer the status quo. However, at the end of the day, we also have to accept that tackling IFFs is a governance issue and also a political issue. The report of the FACTI panel, that's the panel on financial accountability, transparency, submitted February 2021, and of which I was privileged to be a member of the panel, identified gaps in the international financial architecture, in accountability structures, transparency, integrity, and especially in the international financial system that enables illicit financial flows. We must not forget that when the pillars of today's international financial architecture was being built over 100 years ago, an architecture which comprises legal agreements, the institutions, the formal and informal economic actors and professional groups, and the myriad of gaps dug in this process, African countries were under colonization, and they had no voice at the table. Therefore, those rules, the practices, and the institutions do not speak for us, and they do not work for us, yet we're part of this international architecture. For example, considering that the headquarters of most of the multinational corporations are domiciled in the global West, and we have a situation where the rules of international corporate taxation favor the home countries of these multinational corporations, with the right to tax them as opposed to the host countries where they do business and make profit and leave behind environmental and other challenges. How do we resolve such obvious conflict of interest other than by sitting around the table to design a new and a more equitable, just tax rules and more equitable and just international financial system that takes account of everybody's concerns? This and much more is exactly what the FACTI panel recommended, and this is what the historic resolution adopted by the United Nations on the 23rd of November, just a few weeks ago, 2022, led by Nigeria and the African group, seeking to place the conversation on international tax cooperation at the doorstep of the UN, where every nation has a voice and not within regional conclaves controlled by rich countries alone. This is the undoubted and guaranteed route to joint prosperity, which we all talk about. That joint prosperity is what we need. The opposite, of course, is what fuels human trafficking, illegal people smuggling, and migration, and global organized criminality, because people simply want to drift towards economies that appear more prosperous and more stable. In order to solidify this vision from a regional and an African perspective, the AU heads of government in February 2020 adopted the Common African Position on Asset Recovery, the CAPAR, to underscore the importance of the globally acclaimed AU high-level panel report, otherwise called the Thabo Mbeki panel report on illicit financial flows, titled Track It, Stop It, and Get It. Barrister Akere Muna was a member of that panel. The CAPAR provides a major framework for implementation of the critically important recommendations of the Mbeki panel report to African countries, in particular, and for global international financial and governance architecture in general. So what should we be doing? African countries need to bring together their resources and their power in order to push for solutions that have been identified by many different studies and different processes. President Thabo Mbeki recently identified 3 principal challenges to addressing IFFs that need AU's attention, but also global attention. First is to build capacity to combat illicit financial flows at national, continental, and international levels, to establish a global coherence on agreed actions between African countries with a common position on the Mbeki report itself and the AU Special Declaration of 2015 on the report, and vis-a-vis non-African countries. And then to develop global mechanisms to ensure adherence to implementation of whatever is agreed as the solution. Nigeria, as a front runner in this regard, even though we're still struggling with data-specific IFF, we have in the interim as a country taken a number of measures to stem illicit financial flows and enhance asset recovery. Such measures include, in recent times, the Voluntary Tax Compliance Program, which enables taxpayers to normalize their tax affairs previously unreported. So, for example, funds transferred or held overseas for tax evasion purposes. These voluntary programs typically involve a tax amnesty on the condition that the funds are returned to the country and the tax paid. This program is consistent with relevant anti-money laundering rules to avoid abuse. And very recently, we can remember the Voluntary Assets Income Declaration Scheme and Voluntary Overseas Assets Recovery Scheme in focus. Nigeria's Proceeds of Crime Act just passed a few months ago, May 2022. Among
use of Africans, for African citizens, consistent with the principles of sovereignty. You might wonder why CAPAR, when now the basis for CAPAR on the African continent is Articles 1 and 19 of the African Union Convention on Preventing and Combating Corruption. At the global level, the basis of CAPAR is Chapter 5 of UNCAC, specifically Article 57 of UNCAC, which makes asset recovery a fundamental principle. But if you go back to the African continent also, there have been several decisions of the AU underscoring the need for a document like CAPAR. So that is the legal foundation. For the authors of CAPAR, they felt justified by the historical loss of African assets to other jurisdictions. It's not only historical, but we have modern day losses, some from corruption, but largely now from commercial IFFs. So we continue to bleed, and it is felt that without the recovery of the assets that are lost, Africa will be unable to meet the global agenda for sustainable development, several continental and even domestic agendas. So CAPAR is intended to give Africa a voice at the international level to create understanding between Africans of their needs to have their assets returned back. These assets, not only money, but also includes our artifacts. Countries like Nigeria recently had some artifacts returned, but a great deal still needs to be done. So we feel that CAPAR is an important instrument to assist in the identification of where these assets are located, in the investigation of where the assets are located, and also to oil the process of repatriation so that they can be used beneficially. The preamble to CAPAR emphasizes the historical and modern context of asset recovery, but it also recognizes that asset recovery is essentially is political, but it's also economic. If countries feel that their companies cannot afford to lose money held in banks, that jobs will be lost. They may not quickly want to part ways with their assets. But we all feel that there's a shared interest in having these assets returned so that in a country like Nigeria, for instance, we have a phenomenon called Japa, where the young people want to leave and they have a sense that there's a relative inability to have their needs met. So these needs cannot be met if resources that belong to a country like Nigeria are not returned. CAPAR has 4 main pillars. The first pillar is detection and identification. The second pillar is recovery and return of assets. The third pillar is the management of assets. The fourth pillar is cooperation and partnership. These pillars are followed by issues that cut across the 4 pillars, and then it is concluded with policy recommendations. On detection and identification of assets, CAPAR calls for the strengthening of domestic regional systems, and it also calls for transparency and accountability and use of technology. We heard a lot in the course of this conference about how technology can aid in anti-corruption. Technology can also assist in the identification of assets. It can also assist in strengthening institutions. The second element of Pillar 1 talks about regulation and protection, and also incentivization of whistleblowers, which my colleague is going to talk about. The third element of the second pillar talks about strengthening and enhancing institutions, which my colleague to my right will speak about. And the final element of this first pillar is to encourage and advocate transparency. This pillar envisages that all the 4 elements will have to be implemented in tandem for detection and identification to be achieved. Then the second pillar, recovery and return of assets, it calls for prioritization of asset recovery at domestic, regional, and global levels, including what I've said earlier on, the return of artworks and artifacts, such as our Benin bronzes in Nigeria. It also calls for the strengthening of legal and financial institutions to aid process of asset recovery, including the establishment of funds, trusts, and dedicated African escrow accounts to be held by regional financial institutions. Dr. Steve is an expert on that, so he will probably bring you to speed on that. Then the third pillar talks about the management of recovered assets. 2 days ago, in one of the sessions that I attended, I think it was a speaker from the Basel Institute of Governance that spoke about seized vehicles losing their value because of poor management. So the third pillar of CAPAR, it speaks to the strengthening of institutions to capacitate them to better manage assets that are recovered, repatriated, or seized at the domestic level. But this pillar emphasizes that the power to manage should also include the power to invest, return assets, and adopt profitable and economically effective and efficient asset management standards in the interest of member states and their people. To my own mind, the current system where what funds that are returned, the use to which they are put to, are dictated from outside. It does not always work well. Yes, you want to invest in health, in education, but if people cannot travel to the health centers because there's no road, that would defeat the purpose. But if a corrupt-free government is allowed to choose the projects that the returned assets can be used for, I think it will work better both in the short term and in the long term. Then time is an enemy, so I will not go through all the recommended actions for asset management. Let me skip to the fourth pillar, which talks about cooperation and partnership. This pillar recognizes that without cooperation within the continent and with our partners abroad, that asset recovery may not always work smoothly. I think Nigeria is very well experienced at this. Cooperation is required. Information sharing in identifying, locating the assets, and also information sharing in sometimes determining what fines are used for, and information sharing in assessing administrative costs, which Professor Bolaji Owasanoye earlier mentioned. They are important in confidence and trust building. This pillar, it notes that effective and efficient cooperation between various actors, including states, regional bodies, the global community, investigative bodies, law enforcement agencies, and financial intelligence institutions is crucial in curbing IFFs. If you impose a hefty fine and from maybe the payment of bribery to local officials, and the judgment is placed under seal, making it impossible for local law enforcement to identify those who collected the bribes, it doesn't work well, because at the end, the person remains in system, can aspire to other positions. So cooperation is crucial. Then the cross-cutting issues, the issues that cut across all the four pillars. In summary, it includes strengthening of domestic, regional, and international systems. The domestic, regional, and global systems includes the justice sector, an area that personally I am close to. Then another important cross-cutting issue is inclusivity. We cannot talk about asset recovery, the use and management of recovered assets, without considering the impact on vulnerable groups like women, children, the youth. So inclusivity is very important. Then the enablement for achieving these goals or implementing CAPAR, it requires time-bound, relevant policy and strategic implementation, including allocation of resources to asset recovery activities. Professor Bolaji mentioned earlier on that we have a new POCA in Nigeria. This legislation, it has made provisions for a percentage of the value of assets recovered to be used for law enforcement. But there's also a control to ensure that there will be no law enforcement for profit. So there's a balance in our POCA. Then the policy recommendation, which quickly is my last point, it talks about, it recommends strengthening of domestic regional systems for detection and identification. It also calls for the creation and maintenance of agreed framework for management of recovered assets. It also calls for implementation of strategies to enhance transparency in the management of recovered assets. I'm happy to tell you that the agency that I work for, the ICPC, because POCA allows each agency under our legislation to sell assets that are finally forfeited by courts. We have leveraged that provision now to come out with a guideline on how assets will be auctioned. And civil society, the media, they are observers in our process. So that's an area that I'm happy to report on. Then one of the essential policy recommendations.
Just conclude, Esa.
Okay, in conclusion, CAPAR, like sorry, sir, CAPAR is a political policy and advocacy instrument. It's not a legal instrument as such, but it's an instrument that we believe can assist in the negotiation for the repatriation of assets that are held abroad. Thank you.
Thank you very much, Esa. This is a tough session to manage because soon after this we have the fireside chat with Secretary Blinken, so I know that everybody has their own watch. The third pillar you mentioned, which is the management of these assets, is something that has been worrisome to many of us in the global south. Because sometimes these banks keep this money for so long, and the banks, I always say they are complicit because, you know, when the World Bank talks about stolen assets, this money are in the bank, that's where they are kept. And those of us who are lawyers know that if you're keeping stolen goods, I mean that you're a handler of stolen goods. And so the question is, should these banks that have been complicit in the thieving process, do they have any moral basis to keep that money? I don't think so. So the question is, how can we stop them from having to use this money or managing it when it's in their account? I mean, the glaring case was that of Haiti. Haiti was in a really difficult position. They had had disaster and all that. And there was $6 million sitting in a Swiss bank. And they were insisting on all sorts of procedures to be able to get the money back. So that, I think, in the CAPAR, that's why the third pillar, the management of these. And somebody will talk about this is Stephen Karangizi, who was a lawyer as well, of about over 35 years experience. He's worked with international organizations, Assistant Secretary General of SADC, UNICITRAL, and many other international organizations. But of late, he was the very first director and CEO of the African Legal Support Facility that was put together by the African Development Bank. And within the working group, he's been thinking hard on a system or a mechanism that can help the countries pending their claims, pending the repatriation of the assets, what happens to that money? Of course, you can imagine that the countries of the global north where the money sits feel that, you know, it is important that in certain cases as the countries to prove that when the money goes back, it will not be embezzled again. I think it's a funny approach. And secondly, you know, in other cases, it's just delay through procedure. So, Steve, what is the mechanism?
Thank you very much, Mr. Chairman. I think, first of all, you've made my work easier by explaining the predicament which we are in. And our opening speaker, Professor Bolaji, also made it easier by giving the background. And basically, we all are aware that lots of African assets, both liquid and non-liquid, are held outside the state. In the case of the liquid, as the chairman is indicating, we have a challenge of recovering those assets, liquid assets, which are held mainly in commercial banks, even when we've identified them. So in terms of the background, the Mbeki report on illicit financial flows, as Professor Bolaji was highlighting, actually recommended and called for having a framework to handle frozen assets by creating an institutional escrow system in at least a regional development bank on the continent. So what we are faced now is how do we convert that decision into reality? So what we've started with in terms of implementing the CAPAR, which my colleague Esa has been highlighting, is having a legal framework that includes the establishment of an escrow account within our development banks. It can be either the regional development banks like the African Development Bank or the African Export-Import Bank, AfriExim, based in Cairo, or the sub-regional development banks. But we are already having consultations with them in terms of how will we have that escrow account. And as the chairman has indicated, one of the challenges most of our countries face, in fact, not most, all our countries face, is that even when the assets have been identified, there is always a retort from the commercial banks or from the respective states. We will keep the assets, the liquid assets, until the whole process is completed. The problem with that is that there is a danger of the erosion of value of those assets. We can only manage to have an escrow account if we work collectively as a continent. So we are saying that this escrow account should be established in the name of the continent, so the African Union. And we have a basis for that in terms of the background. Chapter 5 of the United Nations Convention already provides in Article 57 for the return and disposal of assets, and encourages that. So we can use those particular existing provisions for enforcing the creation of an escrow account, which would be with a neutral institution and which would be convincing. And we have also heard that the CAPAR we have passed also provides for the recovery and return and management. And we are also arguing that we should be the ones managing those resources, or rather an independent institution should be managing the resources, because one of the challenges we have is that eventually when the resources are being returned, they want to charge, the commercial banks particularly, want to charge an administrative fee, so-called administrative fee, and you wonder what where that has come from. Finally, of course, we have a global forum on asset recovery, one of which principle calls for the disposition and transfer of confiscated stolen assets, and we are saying that those assets should be deposited in this neutral escrow account that we are in the process of establishing. And the further justification for this is that we have some of us have experience. In my previous organization, we recovered some of these sovereign assets in the foreign banks. Unfortunately, with time, the value is eroded. What was $1 billion 10 years ago is not 1 billion today, but they always return the actual unit value. It will also enhance the whole credibility of asset recovery process, because quite often they argue that our countries are not making enough effort to recover those assets. So we can also argue if the assets can be placed in one of the development banks on the continent, and they continue to add value, as my colleague Esa was proposing, then it increases the credibility and encourages our countries to pursue the recovery. The third issue is the asset preservation in terms of the risk of retransfer. In one particular case which I was involved in with my previous organization, the funds were originally transmitted to Switzerland. By the time we got involved, they had already moved through 2 different locations. We eventually recovered them from a third state. So having the funds immediately transferred to the continent in a development bank means that you ensure that they are preserved and their identity doesn't change even after you have identified them. And as I've said, the escrow agreement, which we are proposing with a continental development bank or regional development bank, would encourage our countries to invest in asset recovery, because it is not a cheap process, it's quite expensive. And we also are suggesting, in terms of the legal framework that we are going to develop, we will have easy-to-pick model agreements for the countries, because that's one of the challenges they have. Most of the countries are always provided with the agreements for the recovery of the assets, and they are then not able to provide for transfer of those assets into a neutral account. So we are saying that there should be provisions in those recovery agreements for those assets to be transferred to those neutral venues. Finally, of course, we would also be able to provide for how the funds will be disbursed. If they are being held by a development bank, then that should be easier. The development banks are already giving grants and loans to our own governments, rather than the current situation where the recipient countries insist on a methodology of how those assets should be utilized. In some cases, there's one particular case, one country where they insisted on buying ambulances, which the country did not even need, maybe 100 or 200 ambulances in terms of what you are saying. Then you've lost an intended benefit of using those funds. So we are quite advanced, as I've indicated, in terms of the process. We have discussed with some of the development banks in Africa in terms of how we can conclude agreements between the AU and them. And then we will also be encouraging the African governments. We'll have model agreements and model clauses for them to use when they are negotiating the return of the assets. And we think that that will also shorten the process, the legal processes, which are very complicated in the recipient countries, the countries holding the assets. And we are also looking at ways in which we can manage not just the liquid assets, but also a quick conversion of the non-liquid assets. We've heard how they lose value, like vehicles or whatever, into liquid assets with a value tag that we are aware of, which can then be deposited in the escrow accounts that we propose to establish. In conclusion, we think this will increase the credibility of the asset recovery process. It will be a major deterrence for transfer of those assets to those jurisdictions where it is difficult to recover them. And most important, it will minimize the asset value erosion. So we hope all the African countries will come on board and use the existing instruments that we'll put in place. Thank you very much, Mr. Chair.
Thank you, Steve. It's very interesting, this escrow account issue. Everybody has heard about the seizures and the sales of property belonging to the current Vice President of Equatorial Guinea. And the problem is, in the meantime, where does the money go to? Because, those who are supposed to have taken the money are still there on the ground. So what do? Do you send it back to them? So it is thought that an escrow account, and from that point of view, some countries of the global north have gotten very smart. They have put in place a procedure whereby there's a kind of an account which is held by the government, where they will now function as an escrow, that the money would leave the commercial banks and go to them, but it stays in that country, which doesn't solve our own problem. So it is really something to watch out for as it gets more and more important. The fight against corruption cannot be complete without an efficient whistleblower component, especially in our countries in Africa. You know, how do you protect whistleblowers? Because they're an essential part, essential component to the fight against corruption. And many countries are still shying from that. The next speaker, Roger-Claude Liwanga, who is a professor in 3 universities. I don't know how he does that, in Albany, Emory, and also Harvard, has been working a lot on whistleblower legislation, and we thought it would be great for him to give us a short overview of what he thinks could be done as regards the protection of whistleblowers. Roger-Claude.
Thank you very much, Barrister Akere Muna, for.
I will just alert you that we have a time constraint, so
I'll be speaking in less than 8 minutes, so
okay,
I'll be counting my slide.
Okay, all right, thank you.
Yeah. Good afternoon, ladies and gentlemen. My remark will be on the tool of tools, whistleblower protection, as a necessary instrument in helping CAPAR to achieve its missions. I think Dr. Esa just mentioned earlier that CAPAR was established in 2020 as an important tool in the process of negotiating the return of assets back to Africa. Because according to the high-level panel of experts on illicit financial flows, African continent has lost collectively between 1970 and 2008 about 1.8 trillion. And every year, African continent is losing in the vicinity of 150 billion. And if this trend continues, that means that by 2040, the African continent will be losing in about 1.7 trillion. But the question is that before recovering the illicitly removed assets, one must first detect and identify where are those assets. And of course, most of the time, corruption is prospering where there is minimal possibility of detecting acts of corruption, and that most people who are able to help in prosecuting corruption are those who work where such misconduct are happening. Therefore, it is important to protect whistleblowers, those who act in the good faith for public interest. And sadly, in many African countries, they have adopted legislation or penal code with broad definition of defamation, including the Democratic Republic of Congo, which expose whistleblower to the high risk of criminal prosecution for disclosing act of corruption or even act of illicitly remove assets. It is important to encourage them, and that because he raised the question, how could a whistleblower speak out about act of corruption or speak out about assets that were illicitly removed from the country without being protected? So in that context, they would prefer to stay silent and to turn blind eyes rather than helping the continent. Therefore, it is important. And of course, the African Union Convention Against Corruption has provisions recommending or compelling states to adopt legislative or other measure to reinforce the protection of whistleblowers. Unfortunately, only 10 out of 54 African countries have adopted Whistleblower Protection Act. And if perhaps today it is time for the African Union, and specifically in the context of CAPAR, to think about a more comprehensive legislation at the continental level. And perhaps also leaders in the African continent can look around, for instance, in North America or even in Europe, where whistleblowers are protected and whistleblowers are contributing to the recovering of assets. If we look at the situation in the United States, for instance, the Securities and Exchange Commission recovered about 3.6 billion in 2017 alone, and that 3.4 billion were obtained or collected with the help of whistleblowers. And since the establishment or the creation of the IRS Whistleblower Office, over 5.7 billion have been collected. It is the same thing in Europe. In 2016, with the Panama Papers, and we also learned that whistleblowers contributed in providing information about 200,000 shell companies, including those involved in tax evasion and money laundering. And following the Panama Papers, the European Parliament adopted the Whistleblower Directive, which is increased the protection of whistleblowers, and also the office involved in asset recovery in Europe also benefits with the assistance of whistleblowers in that process. So I'm calling for the adoption of a comprehensive policy in Africa protecting whistleblowers as a part of asset recovery. And of course, that policy should provide clear mechanism about the process of disclosing the information, also increasing the accountability of companies and preventing them from retaliating against whistleblowers. And also, maybe that directive or that policy could be considered as a an additional protocol to the African Union Convention against corruption. So in conclusion, I think I'm in good timing. So in conclusion, if CAPAR could be considered as an important tool in the process of recovering assets from Africa, therefore, the whistleblower protection policy should be perceived as the tool of the tool in order to help CAPAR to achieve its mission. Thank you.
Thank you. Thank you, Roger-Claude. Just to remind the audience that CoDA is in the process of getting to a partnership with the Albany University to see how this could be explored. Now, implementation is something that bothers many strategies, and at CAPAR, the one who leads the group working on implementation is Mr. Dan Dia, who is also a lawyer. He's the CEO of the Pan-African Lawyers Union. Pan-African Lawyers Union, I'm honored that we put that into place 20 years ago. I see in the audience a gentleman who was part of that process, who is now senior counsel at the Department of Commerce, Nandi, sitting right there. That's when we try to get together all the bar associations, regional and sub-regional bar associations of the continent. There were Lusophone, Francophone, Anglophone, and all that. And we're able to put together now the Pan-African Lawyers Union. And Don has done quite a bit to make this organization a good partner of the African Union and he accompanies the organization on its expertise. And also, Don has been very active in human rights issues, and he also looked at the linkage between corruption and human rights. There are people who are even advocating that the African Union Convention should actually be looked at again to have this human rights component. So, Don.
Thank you very much, Akere.
I hope you will be done in 5 minutes.
Okay. Okay, Akere. I think that's actually a good idea. So we have a bit more of an interactive debate. And I think it kind of helps that I think both in your framing remarks, but also the 4 previous presenters, I think I've said pretty much all that needs to be said. The historical foundations of what led us to CAPAR, the political foundations of it, the legal foundations of it in the law of the AU, the Anti-Corruption Convention, AU Agenda 2063, which is our comprehensive 50-year roadmap for the development of Africa. And then between Esa and Steve, I think they've also spoken about the CAPAR itself, its 6 pillars, ending up with the policy recommendations, and actually given a couple of the practical experiences and uses of it. For instance, the work Steve is doing around a draft legal instrument for setting up the escrow accounts in African, continental or regional development banks, and also the templates which source countries in Africa can use for negotiation with destination countries, whether in Africa or beyond. So I think that already has been covered. So as an association of professionals, as Akere said, but also as a civil society organization on the continent, we can just say that PALU has been very privileged and very happy to be part of the process of developing, adopting, and ultimately implementing the high-level panel on illicit financial flows, and Mbeki panel report, which of course was adopted by a special declaration of the Assembly of Heads of State, and therefore now forms not just the policy of the AU, but also the law of the AU, because Assembly decisions and declarations are law. Similarly, we were very, as part of implementing that, and being one of the civil society organizations that His Excellency President Thabo Mbeki appointed into the consortium to implement the Assembly Declaration and the Mbeki Panel Report. We're also very privileged to be part of conceptualizing, proposing to the heads of state, developing, adopting, and then implementing CAPAR with these 6 pillars. And as has been pointed out, that it focuses both on financial and non-financial assets, current, as well as historically, illicitly procured assets, including African cultural heritage and artifacts. I'd also point out that PALU was also quite happy to be part of the advocacy processes around UN FACTI, which I think Bolaji spoke about, the United Nations High-Level Panel on International Financial Accountability, Transparency, and Integrity for achieving the 2030 agenda. And we're happy to do that both as PALU, but also in our consortium, such as the Stop the Bleeding Consortium, which is a consortium of 7 leading Pan-Africanist organizations, all operating at the continental level, many of them membership organizations and covering the continent, but also globally with the Financial Transparency Coalition, which again is a coalition of 13 civil society organizations, PALU included, Tax Justice Network Africa included, which come from the global north and global south and work on financial integrity issues, including IFFs. And their FACTI report was adopted last year, February. So I think all these demonstrate how civil society organizations and citizens organizations can work proactively with government, and it's government at the national level, but also our sub-regional bodies, the regional economic communities, the regional organizations, and also our continental level bodies, the African Union, but others, the African Development Bank, Afrexim Bank, the African Legal Support Facility, which is a major partner, I think has not been mentioned enough, and also at the UN level. So it shows that relationships are not necessarily always conflictual. We're also able to work together in developing law and policy, adopting them, and then implementing, awareness raising, capacity building with various actors, governmental and non-governmental and so on. So that's one thing. But I think the entire process of working on this, especially the UN FACTI process that ended or that was adopted last year, also brings out the hypocrisy of some governments and also the duplicity of some governments, especially some of the governments in the global north, where when it's about the rhetoric of combating corruption, the rhetoric of domestic resource mobilization and so on, they'd be good at the rhetoric. But now when it comes to implementation, you can see them being obstacles and actually being very obstinate, sometimes including threatening actors, like the way actors were threatened in the development of UN FACTI. When it now comes to, when the rubber hits the road, beyond the rhetoric, getting the assets back so that they can be directed to development, I think that has been quite stuck. So as civil society, we are very keen on advocating for the moving beyond rhetoric, and when it's about repatriation of the assets, financial or non-financial, for them to be repatriated in the shortest reasonable time, without politics and without use or misuse or abuse of legal systems. And that's why we're strong supporters of practical establishment of the escrow accounts, but also rule of law and efficient, if they're going to be political or judicial exercises in the destination countries, that they be very efficient. So in country, we do work as civil society, PALU and its partners, we do work with the member states, helping in raising awareness in the relevant governmental offices, but also with citizens, helping in building capacity, again, within governmental organizations, but also with citizens, helping in audits at the national levels of the laws and of the policies that underpin IFFs or that need to be reformed in terms of IFFs and also in terms of CAPAR, having capable financial intelligence units. The professor has spoken about whistleblower protection, speaking about whole of government approaches and multi-government approaches around asset tracing, recovery, and so on. And we're also keen, as a body of lawyers, working with public interest litigation in order to hasten the recovery of assets. And that's public interest litigation in national courts, sub-regional courts, continental courts, and not just in the global south in Africa, but even in the global north, even if it means name and shame litigation, disruptive litigation that brings to the public the attention, the need for a quick and efficient return of assets. So maybe I stop there, Karen, to save us time.
Thank you very much. Before we go into a 15-minute Q&A session, je vais inviter M. Thierry. He's the head of the agency, the anti-corruption agency of the DRC, and he's going to give us a couple of minutes of perception of what is happening in the DRC. He'll be speaking in French, I think, and Roger-Claude and myself would attempt. Really? Okay, so that's it.
Okay.
Vous avez la parole.
Merci, Président Akere. Merci au CAPAR. Un grand merci à Transparency International pour l'opportunité. J'aimerais, avant d'entrer dans le vif de 3 minutes dans lesquelles je vais exposer, nous sommes le 9 décembre, journée internationale de la lutte contre la corruption. Et cette journée se passe dans un contexte assez particulier pour la République démocratique du Congo, mon pays, parce qu'au moment où je vous parle, il y a des atrocités qui se passent à l'est du pays. À Kishiché, il y a eu des massacres de nos populations. Il y a une agression du Rwanda qui soutient le M23 et nous tenons du haut de cette tribune à dénoncer cette agression qui fait pleurer la population congolaise. Pour revenir à notre thématique du CAPAR, les exposés ont été assez clairs. Dans le cadre de la République démocratique du Congo, j'aimerais soulever juste 2-3 petites choses. La toute première, c'est qu'il existe au Congo, en République démocratique du Congo, la COGEBISCO. Je ne sais pas si le prof Liwanga va faire la traduction, je peux continuer. Oui, d'accord. La COGEBISCO, donc, qui est la commission qui est en charge de la gestion des biens confisqués, et FOLUCO, qui est un fonds qui est destiné à gérer justement les produits de la confiscation de ces avoirs. Mais leur fonctionnement, à ce jour, a quelques petits soucis. Et je pense qu'au niveau du Parlement, au moment où je vous parle, il y a un projet de loi portant sur le blanchiment d'argent et le financement du terrorisme actuellement au Parlement. Et il y a des articles, justement, qui parlent de ce volet-là, de confiscation et du recouvrement des avoirs volés. J'ai entendu le professeur Liwanga qui a parlé des lois sur la protection des lanceurs d'alerte, n'est-ce pas? En République démocratique du Congo, nous avons adopté l'année passée une stratégie nationale de lutte contre la corruption sur 5 ans, qui s'étale sur 5 ans. Et dans cette stratégie-là, il y a des recommandations, dont justement une loi portant sur la protection des aviseurs, des lanceurs d'alerte. Et la PLC, en synergie avec la société civile, nous sommes en train de faire justement ce plaidoyer-là pour que la République démocratique du Congo puisse adopter une telle loi. Et nous pensons que dans les années, en tout cas les jours, les mois à venir, ce plaidoyer va se renforcer et qu'in fine, ce projet sera soumis au Parlement. Au niveau de l'Agence de prévention et de lutte contre la corruption, les dispositions donnent entre autres comme mission à l'agence de proposer des mesures de confiscation des avoirs. Il y a eu dernièrement, il y a je pense 1 ou 2 mois, la création d'une commission pour le rapatriement des avoirs volés qui se trouveraient en Belgique, de la République démocratique du Congo. Donc nous allons résolument vers l'esprit du CAPAR, n'est-ce pas, pour récupérer les avoirs, non seulement du Congo, mais des avoirs africains qui se trouveraient en dehors du continent. Avoirs liquides et non liquides. Je ne reviendrai pas à ce que monsieur professeur Bolaji et les autres collègues ont eu à relever tout à l'heure. Donc, par rapport au cadre légal donc, africain, dans le cadre de la confiscation et du recouvrement des avoirs africains, nous pensons que au niveau des chefs d'État, en tout cas nous en tant qu'institution, nous allons voir avec les politiques pour que cela soit porté au niveau des chefs d'État de l'Union africaine pour qu'in fine, une convention qui portera sur cette thématique, mais également le projet qui porte sur un compte séquestre qui a été évoqué tout à l'heure, puisse voir jour au niveau du continent. Voilà, je crois que je vais m'arrêter ici. Un tout grand merci au CAPAR.
Merci beaucoup Thierry. I mean, he was very clear. He spoke about the 2 structures in the DRC that are in place to deal with confiscation and another one that deals with the management of the proceeds from that confiscation. And he said also that his agency is working with civil society for the putting in place legislation on whistleblower, and also that a commission was just put in place to manage the return of assets from Belgium. And globally, that's what he had to say. And now this is the Q&A session. We have 10 to 12 minutes for that. So, okay, we'll take the questions. We're going to do this like bingo. I'll just give you a number. I'm going to call your number, then you can. Vous allez avoir le numéro 1. Hein? Okay. Anybody else? 2? 3? Right back 4? 5? Okay. Number 1.
Okay. Thank you. I'm Mouene Guindo from Mali. I'm leading the National Agency Against Corruption in Mali, named the Central Office Against Illicit Enrichment. So what is evocated here is precisely what we are doing. And the CAPAR is a good thing. This is the 2nd time I got a presentation on CAPAR, the first time in June in Bujumbura, and today. My question is, what's done to get it as a convention of AU? Because if it's a convention as the Convention Against Corruption of AU, countries and states are going to be obliged to implement it. It's a good thing to do. The job we are doing in Mali is exactly what the aim of CAPAR, because we are stressing our job on the recovery of assets stolen from the public trunk by public civil servants and invested either in Mali or elsewhere. And we got a study, a research that shows that 30% of what's stolen in Mali is exported elsewhere, in Africa and out of Africa. So it's very interesting and mandatory for us to develop tools and ways to be able to identify, to seize, to freeze, and to get back those goods stolen from our countries. So what is the challenge is to be able to implement this. As soon as we are going just to speak, to get speech, we are not succeed. What we have to do is to be able to implement it. And in Mali, we are facing a lot of challenges in the area of asset recovery. And this shows that to recover the asset is the thing to be done. Because if people are afraid of this job, this means that this is what to be done. As soon as this is what to be done, I think that we must go beyond the speeches and be able to act. The first step, I think, is to get it as a shape of convention of United Africa Union to get it mandatory for the states to implement it. What do you think about this?
Thank you very much. We'll take number 2. Yes, lady.
Good afternoon, everybody. My name is Esther Coulibaly. I'm from Côte d'Ivoire. I'm French speaking, so I'm going to do my best to speak in English. Sorry for the mistakes.
You're doing very well.
Thank you. I'm currently working for the High Authority for Good Governance in Côte d'Ivoire. I held the position of Director of Cooperation. So I'm very interested about this topic, and I would like to know more about the strength of the CAPAR, because I don't know, I have never heard about it in my country, so I don't know if my country is part of the process, and I don't know, I haven't understood if it's something binding, it's the convention, because I understand that you want to work with the African Union, but in which framework? It will be a convention or something like that. I would like to know more, because beside that, you spoke about the whistleblower protection at the level of the continent. So it's a very important topic, but can you tell me more how you plan to implement this? Thank you.
Thank you. I think we should maybe have these 2 questions because they are very linked. And I'm going to crave your indulgence, Prof. Bolaji. Why don't we go towards a convention? We've had this debate before.
First of all, there is already a convention. To negotiate a convention takes forever. There is the AUAPCC, which already gives a very good framework. CAPAR, it's a political document. It's a guideline, it's a roadmap about what to do when you are trying to recover assets. Obviously, African countries have committed to domestic resource mobilization, improving the capacity to raise their own revenue for development. Now, a substantial part of this is lost through commercial, seemingly innocuously legal commercial transactions that actually have an undercurrent of illegality through which money is stolen. So what CAPAR tries to do is to call attention to what needs to be done. Now, how you approach this depends on the source or the avenue through which you are losing money, either through commercial transactions, either through corrupt transactions, or the criminal element of it. This will determine how you approach it. Now, what are the immediate things to do? First of all is to build the capacity of your officers to know what to look for. The Thabo Mbeki panel report says, track it. You must know what you are looking for. If you don't know what you are looking for, it will be going right by you and you will not see it. So that's the first thing. The second thing is that depending on the legal framework in your country, because Nigeria is a bit conscientized and sensitized on this issue, this year we passed 3 legislations that enhance our ability to recover assets, both domestically and internationally. So the second thing is you may need to take a look at your laws. So where you need to improve the laws, you have to do so. I gave the example of shifting the burden of proof, especially for lifestyle audit or illicit enrichment. The third thing, of course, to do is to have the ability to be able to trace. One of the things that this initiative in the CAPAR working group we're looking at is being able to trace the assets that are held in the global west, locked in litigation, locked maybe by open source investigation and other measures, just as an indication of what we're looking at. Of course, there are many other studies that give you an idea of how much illicit financial flows, but in terms of amounts that have been traced, that verifiable, that is also something that is being looked at. So it depends on the level of the understanding and the legal framework in the country, if I may say so. Thank you.
Okay, I'm going to take number 3 and number 4. Number 3, who was number 3? Yeah.
Merci, je vais parler en anglais. Namdi Ezera with the U.S. Department of Commerce Commercial Law Development Program. Without further ado, Don, our brother from PALU, was the only one that mentioned regional and or sub-regional entities. The regional economic communities are an integral part of, I would think, this process. Is there a place for the REX, ECOWAS, EAC, SADC, etc., in this process at all? And if not, fine, but I just thought I would ask that question.
Number 4.
Yeah, my name is Deji Olaore. I'm from the USAID Anti-Corruption Task Force. My question is on the whistleblower. I was wondering, are there no good examples of whistleblower acts or laws in Africa? Because the focus of the presentation has been mostly in the West. So I was wondering whether there's none on the continent that we can examine and also look at how is that being operationalized. Thank you.
And number 5, the last one was here. Right here.
Good afternoon, everybody. My name is Baji Coulibaly. I'm from Mali National Anti-Corruption Agency. First of all, my thanking goes to all the panelists for giving us details as far as CAPAR is concerned. So if my memory stuck well, the panelist from the middle wearing the blue tie, in the course of his speech, raised the case of asset auction. Would you be kind enough to tell us more about this? How is it handled in CAPAR? Thanks.
Okay. The question about REX, Don, you want to speak to it, or?
Thank you very much, Chair. Yes, I think we think there's a scope, there's importance of involving the RECs and the regional organizations in the asset recovery agenda, because there's a need for a strong network of policy obligating asset recovery from the continental level to the sub-regional level to the national level. So I think there's importance of that. And also for the political, the awareness raising, momentum building that is required. There's quite a role for the RECs, especially the REC parliamentary bodies, the East African Legislative Assembly, the SADC Parliamentary Forum, the Abuja Regional Assembly, and so on. And we even see scope in terms of building the legal framework. We even see scope of using the regional courts and tribunals, strategic litigation in the regional courts and tribunals to push an asset recovery agenda. So I would say so, yes.
Yeah, and also we should not forget that most of these regs do have sub-regional protocols. SADC and I think same thing in ECOWAS and all that, and that, to my mind, can be the launch pad for initiatives that can build up to a continental process. So I think that's one way of looking at it. And the next question, let me just firstly bounce back to yours about the mechanism of confiscation. Yes, Esa, can you talk to that?
Yeah, I think what Coulibaly did, if it were Nigeria, I would call it point and kill. That's what you do when you go to a fish market and you want a particular one. So, have the fish. No, I mentioned auction of assets in relation to a core policy recommendation of the CAPAR that encourages states to put in place not only asset management mechanisms, but transparent mechanisms for the sale of recovered assets. And I gave an instance that in Nigeria, we have the Proceeds of Crimes Act, and under that act, every agency that recovers assets that a court authorizes or the law authorizes the agency to sell can sell. But that to make sure that it is handled transparently, the ICPC has come up with a guideline. And part of this guideline, it encourages civil society, the media, to observe what the Commission is doing whenever it is auctioning assets. That's the context in which I mentioned it, but I linked it to CAPAR, a core CAPAR policy recommendation. Thank you.
Thank you. Professor Liwanga, since you've done this study, could you quickly, in 30 seconds, give us any best practices on the continent on whistleblower?
Okay. Hello? Yes, speaking about the whistleblower, I think South Africa has one of the most comprehensive whistleblower protection legislation in Africa. And of course, it is not a perfect legislation to the extent that it only protects current employees. That means that those who have left their employers, they cannot disclose the act of corruption committed by employers. So that is some of the limitation. But maybe what our friend would like to know is that the importance of whistleblower protection. Because when we speak about the recovery and the return of the asset, it means that at the first place, those assets are left illicitly. And when most of those people who are involved are also public officials, and they don't remove assets by themselves from Africa to Europe and elsewhere. So that means that if there are legislation or laws available protecting whistleblower, those who observe or who witness the removal, the illicit removal of those assets could speak out and prevent it. So that means that for the CAPAR cannot just say that, well, we are advocating for the returning of assets, but without putting together a mechanism to prevent at the first place those assets from leaving from Africa. So this is why it is important to have that mechanism in place. Because you are running late, I think I'll be having time to discuss with my friend at the corridor around a cup of tea or coffee. I think, yes, let me just outside.
Okay. Thank you. Before you close, I will just make a statement, benefit of our sister from Ivory Coast, because it is a really recurrent problem on the continent. The decisions taken at the level of Addis or at never really trickle down to the countries. Never really trickle. I mean, CAPAR is adopted by the heads of states, but do we have a mechanism that permits decisions taken at that level to really trickle down so the citizens can participate? So on that note, I'll ask you to join me in thanking our eminent panelists.